Christina Curls of the Appellate Defender Office for Mr. Mastis. I would request 3 minutes for rebuttal.
3 minutes is granted.
I'd like to focus my argument on the first issue of the brief and then submit the others on the brief unless this court has questions. And the first issue deals with prosecutorial misconduct. Just briefly, when we review an issue of prosecutorial misconduct, there's a two-pronged test. The first is to determine whether or not the prosecutor's comments fell outside the wide latitude given to prosecutors when discussing the evidence, and the second is determining whether or not the defendant's right to a fair trial was prejudiced by that misconduct. In this case, all four instances of misconduct that we allege in our brief deal with either misstating or mischaracterizing the evidence or discussing facts and making inference not based upon the evidence. Specifically, we assert that the state, in its closing argument, misstated or mischaracterized the testimony of 3 of 7 witnesses who actually testified in this case. The first of which would be the sister of Mr. Mastis, who testified for the defendant. In its closing argument, the state told the jury that Jennifer Mastis testified that Lorenza Mastis, the mother and the victim in this case, loved her children. She said that about her mother, but she didn't say that Mr. Mastis returned the favor. Obviously, he didn't have the same feeling. Now, the actual testimony from Jennifer Mastis was that her mother loved all of her children, and when asked specifically about Mr. Mastis's feelings for the mother, she testified he felt the same way. He had that same love. Now, the state in its brief tried to argue that its comment was merely a reaction. It was merely addressing testimony brought out by the defense. But that's not what they said in their closing argument. In the closing argument, the prosecutor said that Jennifer Mastis didn't say that Mr. Mastis returned the favor. He mischaracterized the testimony that actually came out. He didn't draw an inference from the testimony, from the evidence. He mischaracterized that evidence.
He said exactly the opposite of what she said.
Exactly. Exactly. And, I mean, that seems to be the most egregious of the misstatements that we have. The other 2 misstatements that we have are not direct contradictions from the evidence, but they're still misstating and mischaracterizing what the testimony actually was. The second one is from Officer Gene Johnson, who I believe was the first responding officer at the scene who first spoke to Mr. Mastis. The state told the jury during closing argument that Officer Gene Johnson testified that Mr. Mastis appeared to be a person who had just done something wrong. That was Gene Johnson's testimony. Now, we argued that that was a misstatement or a mischaracterization of that testimony because that wasn't what he testified to. What he testified to is that when he first saw Mr. Mastis after the incident, he didn't find Mr. Mastis to be totally emotional. You know, he wasn't in tears. I felt like he kind of resigned himself to the fact that this had happened. Now, the state once again tried to say that what they said during closing argument was a reasonable inference from what was actually testified to. Our argument is, if what they had done is said, this was Officer Johnson's testimony, from that testimony, we can draw the conclusion, not necessarily in these words, but we can draw the conclusion that Mr. Mastis acknowledged that he had done something wrong.
Didn't the officer also testify that the defendant handed him a knife and said, "This is what I did it with"?
Yes.
Isn't that a reasonable argument based on that testimony?
I guess the difference, the distinction that I'm trying to draw here is I'm getting into the answer to your question, but in its brief, the state mentioned all of this factual testimony of the officer, that he handed him the knife, that he showed him the room, and then said that it's a reasonable inference that he had done something wrong. And I would argue that that's true, that could have been a reasonable inference, and if that was the argument that was actually made to the jury, it would be a different story. But what the argument that was made to the jury is that Officer Johnson testified Mr. Mastis appeared to be a person who had just done something wrong. That was Gene Johnson's testimony. He was giving it to a jury as almost a quote of the testimony as opposed to an inference to be drawn from that testimony. And that's where we think that the misconduct occurs, is almost misquoting, misstating what the actual testimony was.
You're saying that the fact that he said that was his testimony means he was quoting rather than summarizing or inferring from?
I would say that that's what a jury would take from it, is
Okay.
that if I heard a prosecutor say that was the testimony, I would take that to mean that that was the testimony, not that was a conclusion that you can draw from that testimony. And I think word choice definitely plays a big part of prosecutorial misconduct in closing arguments.
I think people say that all the time when they're summarizing. That was John Smith's testimony, that was Mary Jones's testimony.
And I think the difference in this case is that the way that the prosecutor phrased it, because the prosecutor did phrase, Officer Gene Johnson testified XYZ, that was his testimony. And then this goes more to the harmless error analysis, but then the jury had wanted the testimony of all officers, all law enforcement, to be read back to them, and it wasn't. They were told to rely upon their collective memory. So there still may have been some potential confusion about that testimony.
Isn't the distinction more about what we're talking about, whether the circumstances suggest defendant did something wrong versus his appearance was that of a guilty person that had done something wrong? I mean, isn't that the difference that you're trying to draw here?
Right. I mean, essentially what the state told the jury is that this officer testified to an opinion that he didn't actually testify to. Now, the third instance was the pathologist's testimony. The state told the jury that Dr. Peterson also made a statement that was unrefuted in the sense that in his examinations, wounds that are inflicted to the face are of a personal nature. Now, he didn't say the doctor did not testify that wounds inflicted to the face are of a personal nature. His testimony was that wounds inflicted to the face are more often not inflicted by someone who knows the victim. Now, our argument as to why that this was misconduct is, once again, the state said that this was an unrefuted statement by the doctor when he didn't actually use those words. But second, and the state acknowledged in their closing argument that they didn't have evidence of motive. But now they're using the words of a personal nature to almost imply or put some sort of a reason for Mr. Mastis's actions on him at this point.
But in the end, the jury heard the defendant's own statements and admissions that he stopped at the bedroom door, he saw her sleeping, he entered the room, and he repeatedly stabbed her 150 times. I mean, so, let's accept the notion, hypothetically at least, that the prosecutor's statements were stepped over a line or were improper. There's still pretty good evidence here upon which to convict.
And I think that goes to what was at issue in this case. In this case, it was never at issue of whether or not Mr. Mastis stabbed his mother. What was at issue was the intent, whether or not he intended to kill his mother. And when the state in their closing argument acknowledges there is no motive, we have no motive, and in every instance of misconduct that they commit in some way is trying to, I guess, input, that's probably the wrong word, but give the jury a reason to believe why Mr. Mastis would do something like this, from the point of them saying that he doesn't love his mother to he acknowledged that he did something wrong, or he appeared to be someone who had done something wrong, that the wounds were of a personal nature, and then the worst of all was in the rebuttal, where the prosecutor said, and I wonder, as Mr. Mastis stood above his mother, stabbing her on the bed and on the floor after she screamed for him to stop, was this a nightmare that's coming true? This is a worse nightmare of hers, or was this something Mr. Mastis had been dreaming of? There was no evidence in this case that Lorenza Mastis was afraid of her son. In fact, in its brief, the
Don't you think she was at that point? I mean, that's the problem I have with this argument. It may not have been a nightmare she had before this started, but wasn't she living a nightmare as she was stabbed 150 times?
Well, as she was, and I would say that that's probably true, but the wording that the state used implied that this was something that she had been dreading. I have nightmares, and I'm afraid that they're going to come true.
How, explain that to me, how you get that from that wording.
Was this a nightmare that's coming? This a worse nightmare? I mean, I guess to me, a nightmare implies something that you've thought about before. A nightmare that you're afraid of coming true is the situation where you have a nightmare about someone attacking you, and now that's coming true for you. I believe what the state said in its rebuttal implied to the jury that there was some reason prior to this for Lorenza Mastis to be afraid that her son was going to stab her in the middle of the night, that her son was going to attack her, when that inference was in no way supported by anything in the evidence. Even when the state was defending it in its brief, it didn't try to tie it to any evidence. It simply said that it was a reaction, it was a response to the defense argument that...
I don't understand how whether or not his mother was afraid of him has anything to do with intent, which is what you have to argue to get to prejudice, because otherwise you just say 150 wounds, screaming for him to stop.
Well, I think what it comes down to, which is what I argued in my brief, is that the state, in each one of these instances of misconduct, they were trying to bolster the weakest point of their case, which was motive. And I understand that they don't have to prove motive, but juries still want to know why someone would do something like this. And with each instance, and even this last instance where where the state, by saying this, implied to the jury that Lorenza Mastis was afraid of her son, that she had been afraid of him, that she had been fearing that something like this would happen, when there's nothing in the record to support that inference. And the state doesn't cite anything in its brief from the record to support that inference. They say that it's not improper because it's a reaction to a defense argument. You can respond to a defense argument, but you can't make up stuff in order to do it.
Can I move you real quickly to what I'm reading is that the evaluation didn't pan out. There was some testimony that the evaluation didn't pan out, which I took to mean that Mr. Mastis was not able to get an evaluation to use to notice up a diminished capacity defense. Is that a correct?
Just to clarify, the defense did initially try to pursue a diminished capacity, and that Mr. Mastis was incapable of forming the consent. The evaluation didn't necessarily support that, but the defense was still that he did not have that intent in this case.
Well, see, that's the problem I'm having, is that you didn't have the evidence to use that defense. So the exclusion of that evidence destroyed the defendant's theory of defense. If you didn't meet the statutory requirements to utilize that as a defense, why do we care if the defendant still wanted to use that as a theory of defense when they didn't meet the statute?
My argument would be is that there are two different things. One is the diminished capacity, which is that he was incapable because of his mental illness from actually forming the requisite intent. The other is that he simply didn't have the intent in this case. And the district court found, and it found that evidence of him hearing voices was relevant, and our argument is that they just cut it off. Where they allowed his sisters to testify that in the 2 months prior he had been hearing voices, as evidence that he was in fact hearing voices that night.
And so you're saying he didn't have the intent here, not that he couldn't, but he didn't have the intent here because he was hearing voices.
Yes, and based on...
And I don't understand how I'm having trouble splitting that here, why that isn't that of arguing that he has a condition, a mental condition that precluded forming the intent, if you're saying the intent didn't happen because he was hearing the voices and he was stabbing the voices.
Because
I'm split that
and
hair.
I understand it's a difficult hair to split, but in this case, based on what the defense attorney was arguing.
The problem is you have a theoretical distinction between incapable of forming intent and not possessing intent. There's a theoretical distinction.
Correct. And what,
That's the one you're trying to rely on, but the evidence is the same.
and what, exactly, and what the theory of the defense was in this case is that he went into his mother's room to attack the voices, not to attack his mother. So in this case, because he was hearing those voices, he did not have the intent or the premeditation to kill his mother. He was going in there to attack the voices. And while the jury did hear evidence of that he had been hearing voices for 2 months previous, that evidence came from his sisters, and the state attacked that evidence on cross-examination on the grounds that these sisters, of course, loved their brother, and they didn't want anything bad to happen to him, giving the jury the impression that this was a defense that was simply made up for trial. Evidence that this separate officer had known of these voices for years prior, that every time he had interacted with Mr. Mastis in the past, Mr. Mastis told him that he heard voices, bolstered that theory. And it is our argument that under Issue 3, that not allowing, once the district court acknowledged that those voices were relevant by allowing evidence to come in, by not allowing that same evidence from the detective to further bolster that theory of defense, to allow some evidence to come in from someone other than a relative of the defendant, deprived him of his right to present his defense, to fully present his defense.
Just real quickly, if the district court believed Dr. Shannon that the IQ was 80 to 90 and that the defendant was feigning, then that would be sufficient evidence for a denial of that defendant was retarded.
Yes.
Wouldn't you agree?
I would agree with that.
So you're
because
really asking us to disregard Dr. Shannon's testimony?
I mean, in a sense, there was evidence from both. Our argument is that because there was evidence that he was moderately or mildly mental retarded, that the court should have
And our
found that.
standard usually is
And-
if there's evidence of both, then
But
the district court's ruling
I acknowledge
stands.
that there was evidence of both, yes.
I'm just curious about this. Is there an Allene problem with the district court making a finding on retardation or the absence of it to govern a mandatory minimum or
It
to govern a
honestly
minimum?
didn't occur to me that there could be an Allene problem until you just mentioned it.
Something to think about.
In this case, I mean, he was sentenced to the 25, so there was nothing more. Just off the top of my head, I can't think of an Allene problem because it's a dispositional thing. And even this court has said that that the Apprendi doesn't apply to an upward dispositional, even though I would question that now in light of Allene. But under Gulhar, I believe, that an upward dispositional departure, since it's not an increase of sentence, but rather. But like I said, I honestly haven't thought about Allene in relation to this simply because he did receive the mandatory minimum of 25 years. And unless there are questions, I would just ask the court to reverse Mr. Mastis' conviction.
Any further questions? Thank you, counsel.
May it please the court, my name is Paul Kitsky. I am the Stevens County Attorney representing the state of Kansas, and I was the trial prosecutor in this case. And a few things that I want to touch base with in regards to the prosecutorial misconduct argument is that this court has to look at the totality of the evidence, and it looks at all of the evidence that was presented. And in this case, Mr. Mastis stabbed his mom with a pocket knife approximately 150 times. There was testimony from him that she had begged him to stop this. Yes, Justice Jones.
But we only look at the totality of the circumstances if we find there was error or misconduct or a problem, right?
I agree with
And
that.
so you're jumping right to the reversibility?
No, I'll go for the first part and the first two. In regards to the wide latitude of prosecutors being able to make those statements, or the second prong is whether the comments prejudiced the jury against the defendant to deny him a fair trial. We believe that we did not. And there are four arguments that the defendant makes today, and we want to address those in that order. That the first and the fourth argument were in response to statements that were presented on the defense. And the claim to show that it was unreasonable by the prosecutor in closing arguments that it was that the love was not shared for the mother that she had allegedly had for Mr. Mastis. On testimony, the sister said that the mom, without a doubt, loved her children, loved them wholeheartedly, and would never do anything to harm them. The state takes the position that unless there's a skewed kind of love, stabbing your mother 150 times when she's begged you to stop in the middle of the night, when she's provided for you for your entire life, is not the same kind of love that was testified to that the mom had for the son. That was in response to witness evidence by the defendant. The second issue deals with Officer Johnson's statements, and to touch upon, Justice Breyer, your statements that...
I have a question, if we can just step back on that one, the Jennifer testimony, the sister's testimony. I think the quibble that your colleague has raised is that you attributed that to the sister as opposed to just contesting what she said. And the sister said, we loved our mom, our mom loved us, and we all loved our mom back. I mean, that's in essence what she said. Not surprising testimony.
Right.
And I think that the complaint that your opposing counsel is raising is that you attributed to the sister something she didn't say.
Well,
Not whether the evidence supports that maybe you didn't love her as much as you're saying, because 150 stab wounds is 150 stab wounds. You see what I'm saying?
Well,
It's the attribution that's the problem.
in quoting her directly as opposed to inferring that...
Yeah,
that was-
indicating to the jury that she testified that he didn't love her back, which is actually the opposite of what she said.
Well, and if I misspoke on that, then I mean, I understand that that's something that happens.
I understand
and-
your prejudice argument. I just
Sure.
want to focus in on what the complaint is. Okay, thank you.
Well, and the issue that we look at, the second thing, is that when Officer Johnson arrived at the scene, he was called there in the middle of the night. The call was made by Mr. Mastis to come to the scene, and he gives him the knife, and he has a calm demeanor, and he has, I guess, he's not crying or ecstatic or acting irrational, and he says, I want to show you what I've done, and he takes her into the scene, and there's the mom on the floor with the 150 stab wounds, and then he confesses to Officer Johnson at the house, and then later admits to the officer, the sheriff's deputy at the law enforcement center, the same thing, that he went in, stabbed his mom, she asked him to stop, and then he continued that. So the issue that, I guess, appeared to be someone that had done something wrong, that was the inference that we made in that. In regards to the personal nature, Dr. Peterson testified to stab wounds to the face being of a nature that are personal. The state can think of no other relationship between a child and a mother that is more personal. So that inference we would feel is obviously within our discretion, because the testimony was also made that that Mr. Mastis not only had a relationship with his mom, but he was a grown man, and that he had lived with his mom, and he had always lived with his mom, and so that was the inference that we made there.
But I think was established earlier, perhaps with opposing counsel, it's not an inference that was drawn, it was attributing that direct testimony to Dr. Peterson.
And the issue, Chief Justice, in regards to that is that I guess the state didn't say directly quoted, or we didn't say in our arguments that we own to take him word for word that this is what he said. I think the issue that we looked at was the statements and the testimony by Dr. Peterson, and then the evidence that was presented to the jury, obviously was the inference that we made that was of a personal nature. And I don't know if...
Well, here's how I show the language from the trial. Quote, Dr. Peterson also made a statement that was unrefuted in the sense that in his examinations, wounds that are inflicted to the face are of a personal nature. And I'm just saying it sounds like you're quoting Dr. Peterson for that statement and not just drawing an inference from something else that he said. So could you address that?
Well, if it's perceived that I'm quoting him directly, that's not the intent to misquote or to mislead the jury. I mean, that's not the state's that would not be the state's intent in this matter. And I think that if you take that, I guess to go off of Justice Johnson's earlier questions, or to correct me, if you take it the next step, I think you look at the totality of the evidence, and you look at all of the evidence, and I don't think that it meets the standard that it was of bad faith or of ill will to meet prosecutorial misconduct. The other issue that I will touch upon is that in regards to the evidence that, or to complete this, in regards to the evidence of the mental health examination and the denial by the court, there was an examination requested by the defendant. The defendant asked to have an evaluation done in order to present or try to present the diminished capacity argument, and that was determined by the court that the evidence was not there. And one thing that was important in this case is that the defendant tried to, at the jury trial, the defendant tried to, I think, in a sense, try to backdoor, or was trying to backdoor the issue of the intent and the issue of mental capacity.
Well, it actually happened. There were more than one witness made reference to his hearing voices, correct?
That's correct. And I think that was, the issue that caused the state to file a motion limine is that we had asked for that because we anticipated that. And so the argument that is made by the defendant in his brief is that he was denied an opportunity to present a defense, but the statute, clearly he did not meet the standard in that, and he was unable to provide the reports and then to give the state the notice for that. So
was there ever, as a part of the diminished capacity evaluation, did that encompass also a competency evaluation?
At the very beginning of the case, Mr. Mastis was sent to Larned for a competency evaluation, and he was returned.
That's right. Okay. Thank you.
So, and the issue that was important in that case, I think, is that the state took the position in regards to the attempt to backdoor, or the attempt to introduce the evidence of the diminished capacity in regards to how they built up or how they presented the case that Mr. Mastis, I think, so loved his mom, and that he was so dependent upon her, and that's why I think that the court was proper in denying that evidence, because first of all, the statutory requirement wasn't met, and second of all, you could foresee that was something that they were trying to play to the jury, or that they would want to present as their defense. So that's the second issue, or that's the third issue. I will touch upon the issue in regards to let me back up. On the third issue, the other thing that I think is important for the court to consider is that when the defense for diminished capacity was denied by the defendant, that no proffer was made to the court as to what should have been presented, and there was nothing made to the court as to what could have been presented, which therefore this court does not have anything to review as to what that defense would have been. But the second matter deals with the jury instruction for reckless second-degree murder. The parties obviously have briefed that, and I think that Judge Ambrosier, the trial judge, made the finding that there was no evidence as to reckless second-degree murder, and I think that's only bolstered in his reasoning by the fact that he gave the voluntary manslaughter instruction by saying that there's very, very little evidence of that, but that he would instruct that. Based on the evidence in the 150 stab wounds, the fact that it was just Mr. Mastis and his mom, she was asleep, he went in to the room, and stopped before he went into the room, peered through with the light of the bathroom, peered into the room, went in, stabbed her, she begged him to stop, he continued to stab. The court said there was no evidence as to reckless, and I don't think that the trial court made an error in regards to that. If the court, I guess to go back to Justice Johnson, your position, if the court does find, or if you think that of the four arguments that it moves to the point where you evaluate it under the totality of the circumstances, I would just ask the court to look at the issues that I first talked about, the fact that there's no issue, there's no smoking gun, there's no issue in this case that there's any doubt as to who did this. There's no doubt. There's no issue in this case as to Mr. Maestas because of his two confessions, because of the fact that he stabbed her 150 times, the fact that he told two independent officers on two different circumstances of what happened, that I don't think it would be reasonable to think the jury was prejudiced or that the jury could not have returned a verdict other than guilty. The issue as to motive and the issue as to whether we have to prove a motive, the defendant accurately stated we didn't have to provide that. This was a premeditation case. There was absolutely no doubt. There is no doubt as to who did it, how it was done, and so I think the issue is to the prosecutorial misconduct. Even if you find after the first two prongs, I don't think that that it meets that standard. If there are any other questions.
What was your theory of premeditation?
The premeditation theory in this case was that it was the evidence was that Mr. Maestas was laying in his bed and on the opposite side of the house. He was laying in bed. He thought about it. Now there was testimony as to whether or not voices were being heard, but he thought about going into his mom's room. He got up, got his knife, walked around the hall, walked down one hall, made a turn, went back down the hall, looked in through the door, and then also went in and stabbed her. The other thing is that there was no heat of passion, there was no argument, there was no evidence as to any fight or any fury between the two of them, other than when the stabbing started. Obviously, she was trying to defend herself, but there was nothing that Mr. Maestas was reacting to of a fight earlier in the evening, and I think the testimony from the defendant that they presented is that the mom had never had arguments or had never even fought with Michael because she'd always provided for him. So that was the issue that he thought about it. He had time to turn around, and he did not.
So you really focused on thought process before the first stab.
I did. And
This isn't one of those cases where you were really focusing on sometime during this process of inflicting 150.
No, absolutely not. I think the issue was that the thing that was big for the state is not only did he was in his own bed, she was in her own bed on different sides of the house, and that he got up, got his knife, walked down the hall, went down another hall, then he looked into the room. From what he said, the only witness we had is Mr. Maestas himself, and he states he looks into the bedroom, and then that's when he goes in to stab her, and then that's where we focused it at, not after the first stab, but I guess we could have looked at that, especially when he testifies that she screamed for him to stop, and he just kept stabbing.
On the last issue, the refusal to send Mr. Maestas to the Larned State Hospital under 223430. Are you relying on the Atkins case to say it's not reviewable?
That's the case that I had, or Justice Johnson.
Can you help me with that? The way I read Atkins, it said that it's not reviewable because the district court has the authority to send to Larned, but there's no duty to do so. And I'm trying to distinguish that scenario from Jessica's Law 214643. The district court judge can depart from the hard 25, but isn't required to. But we review that under an abuse of discretion, and I'm trying to understand why this. It seems to me that either the definition or essence of discretion, judicial discretion, is that you have the power to do it, but you don't have to.
And I think if you take it in this case, Justice Johnson, there was no evidence presented at all.
No, I'm not talking about. We're talking about reviewability.
Okay.
The Atkins says we can't even review it because the district judge can do it or not do it, and there's no individual right to have it done. And I'm just trying to say that if the judge would say, okay, today, because you're a black female, I'm not going to send you to Larned. Or because you're wearing a tie that's offensive to me, I'm not going to send you to Larned today, that we can't review that for being an abuse of discretion. I mean, I don't understand why this particular statute is so unique that it precludes review of arbitrary, capricious action. Not that happened here, but we're talking about reviewability. Why is that precluded?
And the only argument that I would think, or the only reason I would say that is that if you allow everything to be reviewed as to where they're sentenced or to how they're sentenced in regards to whether they're sent to Larned or they're sent to DOC or whether if this court would allow that to be reviewed, then every appeal would start coming in seeking that. And I think that the court has made it clear that as long as it's a legal sentence, that there is no.
Well, the flip side of that is if the district courts can do whatever they want, whenever they want, why are we here?
Well, and I guess I don't have a good enough answer for you, Justice.
Thank you.
Any further presentation, counsel?
No, sir.
Do we have any further questions? Thank you.
Thank you.
I just want to clarify a couple of things that the state mentioned during their argument. On issue 3, they said that there was no proffer as to the evidence that would have been admitted. However, on page 2 of my brief, I do indicate that during the hearing on the motion in limine, defense counsel told the court the evidence that they wanted to present, which was the evidence of the previous officers having contact with him and Mr. Mastis telling them that he had heard voices. Additionally, on page 17 of my brief, there was an actual proffer made during trial. When the defense attorney attempted to introduce this evidence, state object, jury was sent out. The detective himself, the detective Topless, told the court that in most of his previous dealings with Mr. Mastis told the detective that he heard voices, and that his last dealings were 2 to 3 years prior to this incident. So I just wanted to clarify that there was a proffer. We know what evidence that the defense was trying to admit but did not get admitted. So he may not have said, I formally proffer this evidence, but the evidence is there, so the issue is reviewable. The other thing I wanted to briefly touch on is the ill will argument that the state argued that, well, I may have misspoken when it comes to what the sister actually said, or it may have been a misstatement when it comes to attributing something to one witness or another. I guess our argument is, well, first of all, I did listen to the arguments last month in which this court questioned whether or not ill will is still viable, and I would argue that what's going through a prosecutor's head and why they make the statements doesn't make a defendant's trial any more fair if that affects the jury's verdict. So I would agree, or I don't know, I guess not necessarily agree, but I would make the argument that ill will shouldn't matter. But even if it does matter, when there are only 7 witnesses to testify and the state misstates or mischaracterizes 3 of those witnesses' testimony, I would argue that does reach the level of ill will, that it was repeated. And it is an issue of being careful with the words that you use in front of the jury, and if you're not careful with the words that you use in front of the jury, and it prejudices the defendant's right to a fair trial, I believe that you should be held accountable for that, and that it should be something that the court does take into account. Our argument is that it did prejudice his right to a fair trial, because as the state said, and as I said previously, this isn't a case where he denied doing the act. The only issue in this case was the premeditation and the intent. Now, their argument was that he thought about it, and he got his knife, and he walked to the other end of the house, and he stabbed his mom, meaning to do so. The other argument is, the defense case was that he heard these voices, so he went in there to attack the voices. All of the statements of misconduct by the state go to attack and make the nature of the crime more personal, personal by saying that he didn't love his mother, or the wounds were of a personal nature, or he seemed like someone who knew that he had done something wrong, or his mother had had nightmares about this and was fearing it. That's why we would say that this misstatement and the misconduct by the state did prejudice his right to a